Facing a DUI charge in San Diego? Don't panic, let's deal with it. Let's talk about in this video the many different ways you could get your DUI dismissed. First, by preventing it from even getting filed in the first place. Then we'll delve into what you could do for pretrial motions, suppression motions, 995 motions, 1385 motions, pretrial diversion motions that you could avail yourself of the resources and the current changes in the law here in California. And then we're going to talk about some trial strategies, the different types of defenses that you could prevail at trial if you have the right attorney with the right facts at the right time. Let's get started. All right, so you get arrested and you have a future court date, but technically speaking, no charges are filed yet. You've not been charged with anything. You've been arrested on suspicion of DUI. You may have a court date 6 days out. You may have a court date 6 weeks out. You may have a court date 6 months out. So what do? How do you successfully navigate the process? Well, with the DUI, there's a couple things to keep in mind. There's really two components. You're dealing with the Department of Motor Vehicles, and you're also dealing with the criminal courthouse. First, with Department of Motor Vehicles, you have to be mindful of the 10-day rule, which means you need to request an administrative hearing within 10 days of your actual arrest. Otherwise, you might forfeit the right to contest any future suspension related to your DMV administrative per se hearing process. So be wary of that 10-day DUI rule. You hire the right attorney, the right law firm that knows what they're doing. They should be able to set that up for you. Put your mind at ease. One less thing you need to worry about. Now, one other thing you want to be keeping in mind during this time between your arrest and the potential first court date is what, if anything, can be done to hopefully keep the case out of court from never being filed to begin with. Now, go back to 2004. I was arrested for a DUI. I spent time in jail and I was ultimately released and given a court date. And the arrangement that we were able to work out with the prosecutor was sort of like a deferred prosecution. So imagine a situation where, like it happened to me, where a prosecutor says, hey, you know what? You got 5 months to do the DUI program, to do a Mothers Against Drunk Driving meeting. You come back, you get that taken care of, you show us proof of that, we'll never file your case. Well, how great would that be if something like that was available in California in this day and age, as opposed to 20 plus years ago in New Orleans where it happened to me? Well, there are some things that can be done similar to that in California, particularly in San Diego, and that's to try and open up a dialogue with the prosecutor, right? Especially if you have a low blood alcohol content, or if there's some legitimate issues, whether you were driving or not. More importantly, whether they could prove you were driving or not, or whether there might have been a legal necessity. That's where an attorney could really get involved to try and open up that dialogue with the prosecutor to set the tone, if nothing else, that this is not a case that's going to go away easily if it is in fact filed. And that's the real value of hiring a private criminal defense attorney during this time between your arrest and the actual arraignment, because public defenders may be fantastic in certain situations, but they're not going to be representing you unless and until you have your first court date and charges have been filed. So then you're adopting this wait and see approach where you're doing nothing and just relying on the prosecutor to make the call. Now, one way you could avoid a DUI conviction is to try and get some sort of diversion, whether it's misdemeanor diversion under Penal Code Section 1001.95 or military diversion. But let's be real about one thing. The law is ever changing on this topic. It seems like every other week you're allowed to do military diversion for a DUI, then you're not. You're allowed to do misdemeanor diversion for a DUI, then you're not. But you certainly want to explore that option. Now, what is diversion? Diversion is a situation where the criminal proceedings, for all intents and purposes, stop. You do A, B, C, D, and E, or whatever is worked out and negotiated, whether it's with the court or with the prosecutor. You come back and show proof of that, and the case is ultimately dismissed. Now, that's a little bit different than something known as a deferred entry of judgment. That's where you actually have to plead guilty. You put off sentencing a period of time, and then the case may get dismissed or reduced or something along those lines. So one way to avoid a DUI conviction, diversion. The next best thing would be like a deferred entry of judgment where you have to enter a plea and then get a more favorable outcome down the road, provided you adhere to those conditions. Now, a more common way to get a DUI dismissed, or certainly to be able to put yourself in a much better situation for negotiating a better outcome, will be through the use of pretrial motions. And there's many different avenues you could take. Something like a 1385 motion, something like a 1538.5 motion in the Penal Code, something like a 995 motion on a felony. So let's go into each one, and we're going to talk about how you could utilize that potentially to achieve the outcome that you deserve. First, I want to talk about is a Penal Code Section 1385 motion. Now, this is something that the court has to take on its own. All we could do as your defense attorney is to invite the court, basically to ask the court on its own motion, as ridiculous as that sounds, to dismiss the case. And they'll do that on a couple of situations, rare admittedly with DUIs, but it still is in play. One would be if there's extreme prosecutorial misconduct, the judge can make a finding that in the interest of justice, the case should be dismissed. One would be just as far as there's so many mitigating circumstances that a judge could take it upon himself or herself to ultimately dismiss the case, albeit rare when dealing with the DUI because of the concerns, because of the public outcry, and because the judges a lot of times, admittedly and understandably, want to stay off the radar of groups like MAD and any victims' rights groups out there that are very outspoken against quote unquote soft on crime judges. Another way we see is after trial. You go to trial, they can't convict you. It's a hung jury. So it could be 11-1 guilty, it could be 10-2 guilty, it could be 9-3 guilty, whatever the split is, it's not 12-0 in any direction. A judge at that point can make a finding in the interest of justice that basically it is too much of a waste of everyone's time to come back and try this again because no reasonable jury would be able to convict you, and under 1385 could basically dismiss the case. There's another motion known as an 1118 motion or 1118.1 motion that's made in the middle of trial at the conclusion of the prosecutor's case, at the conclusion of the defense case, basically asking the judge to make a directed verdict. For those of you that are familiar with that in civil land, juries shouldn't make a decision on this. There's not enough evidence. No reasonable jury can convict. Very rare, especially on DUIs, but certainly something within the realm similar to a 1385 motion, that 1118 motion. Now, another way most common in challenging DUIs, whether you're challenging the stop, whether you're challenging the arrest, whether you're challenging the blood draw, the detention, whatever, is a Penal Code section 1538 motion, right? That's a motion to suppress evidence. So whenever we get a DUI case, we're looking at a couple of things. What was the basis for the original detention, right? Why were you pulled over? Why were the cops involved? Was it a checkpoint? Maybe you could challenge the checkpoint. Was it an invalid stop? Did the cops blow it? Did they get it wrong? Did they pull you over for a reason that is not proper, not legal, right? And if there is, the theory being is that if that was wrong, then everything after it should be suppressed and thrown out. And then the prosecutor doesn't have a case because everything usually happens after the stop, right? As far as evidence of being DUI, the blood draw, field sobriety test, all that type of stuff. Another thing that we see a lot is challenging the arrest. So maybe the stop and maybe the detention is valid, right? Maybe they had a right to legally investigate you for DUI and keep you on scene where you're not free to go. But what if the arrest was no good? We had a case one time where, the cop on body-worn camera said to his sergeant, "I really don't know. It's a tough call." And the sergeant's like, "Well, you want to give her a PAS test, handheld breathalyzer?" Cop says, "Yeah, I think that'll help my determination." Well, the client smartly says, "No, I'm good. I don't have to do this voluntary test." And then they arrest her. Based on what? So we filed a motion to suppress evidence challenging the underlying arrest. They didn't have enough before she refused the PAS test. So what does the refusal have to do with whether or not she was under the influence or not? That induced an ultimate dismissal because we filed that motion to suppress evidence based on the arrest. And also what we see a lot of times too on blood draw cases, if there's a warrant, if there's a forced blood draw, was proper procedure followed? Was everything done the right way? Was a warrant necessary? Was the client awake? Were they conscious? All those types of factors where we've had success in suppressing, keeping out blood draw evidence. And if you don't have the chemical test, then what does a prosecutor have to prove, or at least to try and prove, of DUI? Not a whole lot. So a great tool in any DUI evaluation needs to be, is this worth running a 1538.5 motion, a motion to suppress evidence? What's the reasons why we want to do it? What's the reasons why we don't? What are we trying to accomplish? If your attorney's not talking to you about that and not answering those questions to your satisfaction, it might be time to make a change. Now, one thing that we see a lot, and it doesn't necessarily need to be exclusive to DUIs, but it does come up, is something known as a Penal Code section 995 motion. When we say that, we're only dealing with felonies, we're only dealing with felony cases that have had and their case survived through a preliminary hearing. Preliminary hearing, in short, district attorney has a burden to reach. It's a step in the process. They need to put on enough evidence by way of testimony for the charges to stick, right? More likely than not, a felony was committed. More likely than not, the defendant, the accused, committed it. So after that preliminary hearing, there's a mechanism to try and dismiss the charge or charges, and that's the 995 motion. In short, the judge got it wrong at the preliminary hearing. A different judge reviews the transcript, here's the evidence, here's argument, and makes that determination. whether there was insufficient evidence to get past that burden at a preliminary hearing, whether there's some legal ruling that could have had an effect on the ultimate outcome. And the hope is, if you're successful with the 995 motion, that those charges or that charge gets ultimately dismissed to put your client in a better position moving forward, assuming there's other charges that survive, to ultimately get them a better outcome no matter which path that case goes. All right, so all your other attempts to try and get the case dismissed have been unsuccessful, or maybe they didn't necessarily apply to your case. You decide with the help of your attorney that you're going to take your case to trial, which is your constitutional right. What are some trial defenses that you may have to ultimately get your case dismissed, particularly as we're dealing with DUIs? Well, first, let's take a minute to just understand what the law is for a DUI. Your traditional misdemeanor DUI is Vehicle Code Section 23152A and 23152B, driving under the influence and driving with 0.08 or higher blood alcohol content. Driving under the influence doesn't necessarily require a hard and fast blood alcohol content. It's more of a totality analysis, driving, field sobriety test, if any, chemical test, all that stuff, to determine whether or not you did not operate a motor vehicle with the caution care of a reasonable, sober person. 0.08 or higher is a different animal in that you could be fine. You could be going through a checkpoint, but if you're 0.08 or higher at the time driving, then you can be found guilty of a misdemeanor DUI or any type of DUI under Vehicle Code Section 23152B, 23153, anything that goes along those realms. So what are some trial defenses? Well, the first one that's overlooked a lot, unfortunately by a lot of attorneys too, is the fact that you were actually driving the vehicle at the time. Now, there's certain cases, okay, let's be real, you get pulled over, you're driving the vehicle, you don't have a driving defense. But what if you're on the side of the road? What if your car breaks down? What if you're involved in an accident and there's multiple people that are standing outside the vehicle when the cops show up? You could get tested. You could be 2, 3, 4 times the legal limit. But the reality is, if they can't prove beyond a reasonable doubt that you were actually driving the motor vehicle, they have a problem there. That's something that's overlooked. Another thing is specifically as it relates to when you were driving, what was your blood alcohol content? Because that's sort of a hybrid between the driving defense and I wasn't DUI or I wasn't 0.08 or higher, not at the time of the test, but at the time driving. So what if you get in an accident, you go home, you're freaked out, you start having a couple of drinks, cops show up 30 minutes later. You may be over the legal limit, but that doesn't mean you were under the legal limit or over the legal limit at the time driving. How do they know? They don't, unless you start filling in the blanks, unless you start saying, yeah, officer, I haven't had a drink in 3 hours. Okay, well, you're destroying your defenses that way. But that is another viable defense. And then there's also something known as a necessity defense. You know, a necessity defense is basically there was no other alternative. It was the best option to prevent a greater harm. Now, a lot of people laugh when you talk about a necessity defense to a DUI. They talk about, well, call an Uber, walk, don't drink and drive. And prosecutors laugh at this. They laugh at it until you go to trial and until you beat them on a necessity defense. And I'm speaking from experience here because we had a case where our client was 2+ times the legal limit and our defense was necessity. There was no 0.08 or higher at the time driving defense. We did not have one for that. But in that situation, rural part of San Diego County, a friend is over there drinking together. She sees her friend leave on his motorcycle. Looking down this windy road, she sees the motorcycle lights. All of a sudden around the turn, she doesn't see those motorcycle lights anymore. She's familiar with the area. She calls her friend. Are you okay? No answer. Calls again. Are you okay? No answer. Looks down the road, doesn't see the lights at all. And half a mile down the road, people may say, prosecutors, well, why didn't she walk, right? Well, rural area, rattlesnakes, coyotes, 2 small dogs, all those situations that played out in that case. She got in her car, found her friend in a ditch. This client worked in the medical profession and was able to render aid. But when the cops show up, they arrested both of them for DUI. So we had that case and the prosecutor's like, what are you doing? Necessity defense, get out of here. It's a standard DUI. Client had a lot to lose, more than most people because of her professional license and her reputation. Took the case to trial. Necessity defense admitted she was 0.08 or higher, she was under the influence, but the prosecutor then needs to disprove beyond a reasonable doubt that there was no necessity. Well, they weren't able to do that and our client was acquitted on both counts. Not guilty verdicts across the board. Necessity is not super common. It's not for every case. A lot of times, admittedly, if it's a wrong case, you get laughed out of court, but the right case, it will get you the dismissal that you deserve. Being charged with a DUI is a scary thing. Listen, I get it. I've lived it. No matter what your blood alcohol level is, you have viable defenses potentially at your disposal. So not all hope should be lost if you're a 0.20, a 0.25, a 0.30, if they can't prove you were driving. If they can't disprove you didn't have a legal necessity. If they can't prove beyond a reasonable doubt that the chemical tests were done the right way. And even if they can, maybe there are certain things that you could challenge as it relates to the stop, the underlying arrest. Any attorney is probably not going to do a whole lot. A qualified, experienced criminal defense attorney that's lived through it, that's handled these cases at a high level for decades, is definitely going to be able to do a lot. At the very least, it will give you the peace of mind that everything was done to make sure that you protected your freedom, you protected your future, you protected your reputation when so much could be at stake outside the courtroom. So it is essential to understand these things, that not all hope should be lost depending on how serious you may think the case is. And with the right attorney at the right time, most anything is possible, even when dealing with a DUI offense in San Diego.